So in criminal procedure code, the probability of proof that is required is beyond all reasonable doubt, beyond 85%. Now, first, the features of CRPC, let us see. First is organization of criminal courts. This is a hierarchical structure of criminal courts in India. At topmost is the Supreme Court, next comes the High Court, below that is Sessions Court at the district level. Okay, and then you will have additional sessions judges, then assistant session judges, and all criminal these things are done by the judges and magistrate. Magistrate will take cognizance. A judge will not take cognizance of the crime. It is taken by the magistracy. Magistrate will take cognizance. Executive magistrate does not have power in this case. Only the judicial magistrate can take cognizance and then commit the case to sessions. And then the real trial starts at the sessions court. Okay? Before the sessions court trial, whatever procedure happens is at the magistrate court. Right? Next is fair trial. Fair trial means, I told you, accused has the right to be represented. If he is unable to represent, he doesn't have money, he is a poor person, then the government has got the responsibility to give him a good lawyer to represent it at the cost of the government. So there should be an independent and impartial tribunal should be there, and right to cross-examine the witnesses is given to the accused, and the accused is considered to be not guilty until proved. Then protection to the accused is given, special provisions are given. Then the interest of the Supreme Court has given list of rules that are to be followed in case of protection to the accused persons. This particular case is called D.K. Basu versus State of West Bengal, AIR 1997 SC 610. Please remember D.K. Basu versus State of West Bengal is very, very important. If you can, please download it and read it once. Then special provision for protection of the accused persons. Free legal aid is there under Legal Aid Act, and we have every district we have Legal Aid Society, and all the lawyers, most of the lawyers are members of the Legal Aid Society. And if there is a person who doesn't have the wherewithal to hire a lawyer and then represent his case, then the Legal Aid Society is to be approached. The court will order the Legal Aid Society to provide a good lawyer to the accused. Judicial magistrates are under the judicial magistrate is the person who takes cognizance of the criminal cause, and then he is under the control of administrative control of the high courts. And first sessions court also is under the dual control is there. Then trial procedure. Procedure for trial summary cases shall be, there will be three types of cases: sessions cases, summary cases, and other cases. There are three types of cases are there. The trial procedure. Procedure for trial of summary cases shall be the same as that of the summons case, except where there is provided otherwise. That is, summons and summary trial go together. The only thing is, in summary trial, the procedure is the same, but the recording will be less. The recording of details that is made in case of summons case will be much detailed by the magistrate. The duty of the judge will be less. In summary cases, the duty of the judge will be less. What he records will be less. The recording is the only summary portion, whereas the trial will be the same. Court of Sessions also has given power to exercise revisional jurisdiction in addition to High Court. So if you are after the summons case or a summary case, it will go to a sessions court for review. An appeal by the state against the order of the acquittal can be filed only after obtaining leave of High Court. In case of adjournments, costs may be awarded. Mostly costs are not awarded, but adjournment they may award. If you ask too many adjournments, they may award costs also. Now, what is the duty of the police? One of the crucial things under CRPC is the duty of the police. If the police officer refuses to record the first information that is received by him under the commission of a crime, then the aggrieved person does have a right to send information by post to superintendent of police. And if there also he doesn't get any response, he can go to commissioner of police. Even if there also he doesn't get any response, he can come to the court directly. Now, what are the legal terms that are important here? First is the FIR, First Information Report. First Information Report is not actually a report. Okay, it is a report only to the magistrate. Right? That is, first information is received by the police, and the police will receive it from wherever it is, either orally or through telephone or through any other material, and reduce it to writing. The moment it reduces it to writing, it is called First Information Report. It is first in time that is information is received that a crime has been committed. Okay, it need not be an encyclopedia. First Information Report need not contain all the details. If it contains the basic details that a particular crime has been committed at a particular time, place, and things like that, that is sufficient. ठीक है? Yeah. So next is station house officer or officer in charge of a police station. The officer in charge of a police station is an important person in investigation process. In his absence, any person, officer in charge, SI and above, can take the FIR. And a copy of the FIR is to be given to the informant, free of charge. If a copy is not given, then he can approach the SP for getting a copy. The complaint. Any allegation made orally or in writing to a magistrate with a view to his taking an action under CRPC, it is called a complaint. Supposing the police SHO refuses an FIR, even the SP pleads is helpless, commissioner also it does not help him, then you can go and file a complaint with the magistrate. What you call a report in a file in a criminal case to the magistrate is called a complaint. And on that complaint, magistrate will order the police to file an FIR, register an FIR, give a copy to you, and then start the investigation process. FIR, the importance is that it is the first document which sets the criminal law in motion. That's the importance of FIR, nothing more than that. It need not contain all the details, it need not be an encyclopedia, and it does not confer rights or liabilities on anybody. Okay, it only sets the criminal law in motion. Next, bail. Security for appearance of the accused person on giving which is released pending trial or investigation. There are two types of cases here: cognizable cases, non-cognizable cases, and then bailable cases and non-bailable cases. These are defined under Annexure 1. Okay, what are different cases? On this Annexure 1 CRPC, it is there, you can go and read it. Now, in the case of bailable cases, the bail is granted at the police station level. The difference is that bail is granted both in bailable and non-bailable cases, but in case of bailable cases, the bail is granted at the police station level itself, whereas in non-bailable cases, the bail is granted by the magistrate. This is the only difference. In cognizable cases and non-cognizable cases, the difference is that in cognizable cases, the police can straight away write down the FIR and start investigation without getting a permission from the magistrate. But in case of non-cognizable cases, the police have to obtain, they can write down the FIR, agreed, but they can write only the information. A complaint has been received, only that way they'll write, and then they'll send it to ask the person to go to a magistrate and get his order to start investigation. So unless the magistrate gives an order to start investigation, in non-cognizable cases, police cannot start an investigation. Okay, then anticipatory bail. In all these cases, you have a chance, if you have an apprehension of being arrested, if anybody has got an apprehension of being arrested, or if he feels there are baseless allegation for which he may be arrested, he may be framed, then he can go to the High Court and get anticipatory bail. Okay, for anticipatory bail, first you have to prove that there is a likelihood of your being arrested. Okay, that details you have to provide to the court before they give the answer, give the provision for anticipatory bail. The benefit of bail is that not that no arrest will be made, but only that even if it is a cognizable case, even if it is a non-bailable case, if the police arrest you, immediately on producing the anticipatory bail letter from the court, the police will grant bail. That is the only difference. Now, bailable and non-bailable, I told you, bailable offence is an offence which is bailable in the first schedule of CRPC. Okay? Then, warrant and summons case. There are two types of cases. There are warrant and summons case. Warrant case is a case relating to offence punishable with death or imprisonment for life or for a term exceeding 2 years. And summons case means a case relating to an offence not being a warrant case. That is, everywhere 2 years or less. If the punishment is 2 years or less, then it is a summons case. And it is 2 years or more up to death sentence, that is a warrant case. Now, what is the difference between the two? In a summons case, you summon a person, you call a person to come to the police station and give his viewpoint. So and so information has been received that you have committed a crime. These are the particulars of the crime for which you will be, the punishment given under IPC is less than 2 years. So you are hereby summoned to the police station to come and give your viewpoint. So that is the summons case. In a warrant case, the police can go and arrest the person and bring him to the police station. A warrant is given to a police officer to go and arrest him. That means A orders B to go and arrest C. So the person will be brought to the police station and then investigation will be done. Cognizable, non-cognizable cases also, the offence which a police officer may, in accordance with the first schedule of CRPC, arrest with a warrant. Whereas in non-cognizable cases, police officer has no authority to arrest without a warrant. He has to get a warrant from a magistrate. Next terms are inquiry, investigation and inquest. An inquiry is a trial conducted by a magistrate or a court. An investigation is conducted by a police officer for collection of evidence. Whereas inquest is part of investigation and it is also done by the police officer to ascertain the cause of death in a suicide or a suspicious death cases. And police station means where the state government declares it to be a police station and includes any local area specified by the state government under CRPC. Next, the case of the state is presented to the court by public prosecutor. Public prosecutor represents the state in whose name the prosecution is conducted in the criminal procedure court. Public prosecutor must discharge his duties fairly, fearlessly and with a full sense of responsibility. His duty is to assist the court in discovery of the truth. According to CRPC, public prosecutors, additional public prosecutors, assistant public prosecutors may be appointed by state and central government as per requirement of High Court, Sessions Court and Magistrate Court. Now, Constitution of Criminal Court, Jurisdiction and Powers. This is covered under section 6 to 40. There are different types of courts. One is Supreme Court, next is High Court, then is Sessions Court at district level and below that Magistrates Court. Sessions Court contains of Sessions Judge and Additional Sessions Judge and Assistant Sessions Judge. Magistrate Courts consists of First Class Magistrate, Metropolitan Magistrate and Judicial Magistrate of Second Class and Executive Magistrate. Executive Magistrate does not have any adjudicative powers. This is the structure. Okay, now powers of courts. Supreme Court, any punishment power is there. High Court, any punishment power is there. Sessions and district judge, they can impose death sentence, but death sentence has to be confirmed by its High Court and plus or minus fine. Additional session judge can give death sentence, life imprisonment to be ratified by HC and fine. Assistant session judge cannot give death sentence, he can give only 10 years imprisonment. Life also he cannot give and fine. And chief judicial magistrate, he can give up to 7 years imprisonment and fine. Additional CJM can give 7 years imprisonment with fine. CMM can give 7 years plus fine. Additional CMM 7 years plus fine. Judicial Magistrate First Class JMFC 3 years imprisonment and fine. Metropolitan Magistrate MM is that 3 years imprisonment and fine up to 5,000 rupees. JM Second Class 1 year imprisonment and fine up to 1,000 rupees. And Special JM 1 year imprisonment and fine up to 1,000 rupees. Now arrest of persons is dealt with under section 41 to 60. First you have to define arrest. Arrest means depriving a person of his freedom. It does not mean putting iron on his hands or legs or anything like that. That's what our idea of an arrest is. The moment a police officer touches a person or even declares to him that you are under arrest and the other person submits to that intimation or to the touch, immediately he is considered to be under arrest. No need to put him under shackles or tie him with a thread, rope or tie him with iron, these things are all not necessary. Okay, they are actually frowned upon by the court. If the person is willing to come and submit to the authority of the police, the moment he is told that he is under arrest, then there is no need to, in fact, the police are debarred from using any power, any violence on the person of the accused. Arrest may be by touch or confining the body of a person, and if he resists only, police can also use all legal means to effect an arrest. Technically speaking, arrest is a form of state arrest, state constraint applied to a person during which the person is placed under detention. His imprisonment is deprived of his right to move freely. Arrest can be made with or without a warrant. Article 21 of the Indian Constitution speaks about no person shall be deprived of personal liberty except according to the procedure established by law. So state courts and police take every precaution and care in regard to the arrest of a person. Now the rights of the arrested person are given under Constitution and by various declarations of the Supreme Court. Then what are they? Number one, he has got a right to be informed of the ground of arrest. On what basis are you arresting me? That he has to be informed. Second, right to be defended by a lawyer of his own choice if he is able to afford. If he cannot afford, then the government has to give him a lawyer. Right to be produced before a magistrate within 24 hours of being arrested. There should be no detention beyond 24 hours without any authority of a magistrate or a law. Right to know about the charges and see the contents of the warrant. Right to medical examination in deserving cases. Right to have a woman police officer if arrested person is a woman. And duty of the police to follow the guidelines given by Supreme Court in a DK Basu case. Every police officer should take along with him a DK Basu instructions given by. So you are a forensic scientist, you should also have a part of the DK Basu, orders of the Supreme Court. Then power of the police to arrest a person without a warrant. So police officer may arrest without a order from magistrate under the following circumstances. 1. It is a cognizable offence. 2nd, it is housebreaking is in the process. Then stolen property has been recovered from a person. Then he obstructs a police officer in the discharge of his duties. Then he is declared a deserter from the armed forces. Then a person who commits non-cognizable offence in the presence of police and refuses to give his name and address. If you are going on a street in the middle of the night and the police van comes and stops by you and asks for your name and address, you better be sure to give correct name and correct address with proof. Otherwise, the police have a authority to immediately arrest you and put behind bars without any intervention from any court or a magistrate. Then power of a private individual to arrest accused. The best part of our Indian law is that even an individual, a citizen, has been given the authority to arrest an accused. If he comes across him, there is no police nearby, he knows that this person is arrested as a deserter or is a known person who has committed a crime, or he is committing a crime in his own presence. A private person with all his might can arrest the accused and keep him till the police arrives, or take him to a police station and hand over to the police officer. And in such cases, the police will re-arrest him. Power of a magistrate to arrest. Judicial magistrate and the executive magistrate are empowered. Two judicial magistrate as well as the executive magistrate are empowered to arrest a person or authorize a person to arrest accused in the circumstances. That is, offence is committed in his presence and any person against whom a warrant can be issued. One saying is that if a Supreme Court judge and a High Court judge and the lowest level of judicial magistrate, second class, are walking in a park and a person commits a crime in their presence, who has the authority to arrest? Then the person who has got the authority is neither the Supreme Court judge, nor the High Court judge, nor the district judge, but the lowest level of judicial magistrate, second class. This joke, if you remember, then you will understand the above process correctly. Then process of production of person, section 61 to 90. The procedure laid down in CRPC to compel attendance of a person, including the accused and the witnesses, by issuing of summons, arrest warrant, or in case of absconding, declaring the person as a proclaimed offender and attaching his property. These are the three ways you can force a person to compel him to attend a court. Because otherwise you will be sitting in court and everybody will be roaming around freely in the society. You will have no means to bring them to you. So unless they come to you and give their part of it, you cannot pass a judgment. So this is the issue. So there are detailed procedures that are given. One is summons. You are given a summon. Please come and attend the court on so and so date. Now if you refuse or if you don't attend and if you don't honor the summons, then an arrest warrant can be issued. Okay? Non-bailable arrest warrant will be issued. It will be issued to the police. Police will come to your house, arrest you and take you to the. Then in case you are absconding, even after the warrant, summons and warrant also you abscond, then you will be declared as a proclaimed offender and the court can attach your properties or your family properties and then force you, in order to protect your properties, you will be forced to come and attend the court. Next, summons, how to serve. It is a very, very serious issue. Better every police officer as well as you, all of you should know what is the procedure. Summons are issued for the purpose of appearance and for production of a document or a thing. Summons can be for three things. One, a person. Second is a document. Third is a material. Okay? Document and material, they may be available with the forensic science also. It may come to the police forensic science institute and then they come back there. And then the person will be brought for appearance. Every summon issued by a court shall be in writing, in duplicate, signed by the presiding officer of the court and shall bear the seal of the court. Okay, it will be in duplicate because when it comes in duplicate, you take one summon, one part of it. Second part you write received and sign, I will attend. And then give it to the person who is serving you the summon. Every summon should be served by a police officer personally on the person so summoned by delivering it. A copy of the summons of taking signature on the duplicate copy when a person summoned is not present, and the summons may be served on the adult male member of a family. Always remember, female cannot be served, servant cannot be served. A servant is not part of the family. Okay, if only women are there, then it will be pasted on the proximal, any prominent part of the house or on the door. Okay, but a woman member will not given a copy of the summon. It will be served on the eldest a male member in the family, whoever is present, if the person on whom summon is served is not there, someone is named is not there. In case of a corporate body, a manager or a person who is looking after all the affairs, administration, is given the summon. So if they are not available, then it will be affixed on the outdoor of the house in which the person summoned resides, his residence. And if it is a government servant, then it is served on the HOD, head of the department of the person on whom the name is there. Warrant of arrest and how to issue. An arrest warrant is a written order given by a judge and other judicial officer on a probable cause, directing the police to arrest a particular person. Where a person has been concerned in a non-cognizable offence, he cannot be arrested without a warrant. Every warrant of arrest issued by a court should be in writing, must contain the signature of the presiding officer, name of the person who is to execute, name of the person to be arrested, and the seal of the court. Now here, difference between summon and warrant is that summon is in your name if you are to be called to the court. But in warrant is in the name of the, issued in the name of the police officer, not in your name. Your name will be written, who is to be arrested and brought to the court. So that is the difference. There are 3 parties in a warrant, 2 parties in a summon. Please remember that. Every warrant of arrest issued by a court should be in writing, must contain signature of the presiding officer, name of the person who is to execute, name of the person to be arrested, and seal of the court. Every warrant shall remain in force till the arrest is made or it is withdrawn by the court. Okay. Court in its discretion may make an endorsement and warrant for release of the person after executing bond with sufficient sureties. Every warrant issued by any magistrate in India might be executed anywhere in India. It may be forwarded for execution outside the jurisdiction of the executive magistrate or DSP or a commissioner within local limits. Then proclamation of offender and attachment of properties. Where a person against whom a warrant has been issued is absconding or is concealing himself and not allowing a warrant to be executed or a summon, then court may publish a written notice to appear at a specified point, and it may be published in a local newspaper, 2 or 3 newspapers with circulation in the local area, and given 30 days time to come and surrender before the court. And even after that, if he fails to comply with and avoids arrest, the court may issue an order of attachment of properties by declaring him as absconder or deserter. The purpose and object is to compel the appearance of the person, not to take away the property or sell the property and make money for the court. Warrant in lieu of summons. When any person who is bound by any bond to appear before a court does not appear, presiding officer may issue a warrant directing such person to be arrested and brought before the summons is issued. You come to the court and say, yes, I will appear, but on the particular day you don't appear. Okay, then you will issue a arrest warrant. So the process of production of things. Next is FSL is more concerned with the production of things. We are all concerned with the material objects. So the process of production of things is given under section 91 to 105. We should read all these sections of 191 to 105. The court, in order to establish the fact, needs documents, material items, materials and things because they are necessary as evidence. This can be secured by issue of summons by a search warrant. When will a search warrant be issued? First, summon. A summon will be issued to a person who is holding that particular item or the material thing or a document. Then that person is supposed to bring it to the court and submit it to it. In search warrant will be issued to then again to the person, not to the person but to the police officer, indicating under whom, where the particular item is there, and that police officer is authorized to go to that particular person named therein and collect the item and bring it to the court. So, a search warrant is a written order to a police officer or other person, such as magistrate or a court, for search of any place generally or for specified things or documents and wrongfully detained. A search warrant can be issued in the following circumstances. 1. Where the court has reason to believe that the person summoned to produce a document will not produce it, relevant document not known to the court and is possession of any particular person, where a general inspection or a search is necessary, search of a place suspected which contains stolen property or forged documents, search for a person wrongfully confined, power to compel restoration of unlawful detention of woman or a female child, search for publication or forfeited to the government, search of a place without warrant conducted in presence of a magistrate, search by a police officer without any warrant, and police officer has a power to conduct search in limits of other jurisdiction, forms and duration of such warrant. Then when a warrant is directed to a police officer, he may endorse it to another police officer who has jurisdiction. The police officer shall ensure that the search should be conducted fairly by following the procedure established by law. Now, Search of police without warrant. CRPC authorizes police officer to search certain things, documents without warrant, if it is necessary for fair investigation by following the procedure. Now, what is the procedure? In charge police officer may conduct a search or he may authorize it to subordinate in writing. Search may be for things and documents which is necessary for investigation. No general search is permitted. This you please remember. No general search is permitted. Okay, police officer must have a reasonable ground for about search for a specific thing. Police officer must record in writing for what search he is proceeding. In case of non-recording of reasons, the search will become illegal. Police officer must send a copy of findings of search to the nearest magistrate. Search must be made in presence of two independent and respectable inhabitants. Swati, please mute yours. Police officer must prepare a list of things seized. Police officer must give a copy of search to the occupant. Witnesses must accompany the search. And wherever you are going for a search, that means the police first go and search, get two witnesses, respectable person of a local locality, or called panchas, and bring them with them to the search party and then search. Nominee of the accused is permitted to be present during search. In non-compliance of the above said procedure, states above violators will be liable to pay damages. Under section 102 CRPC authorizes a police officer to seize any incriminating things other than those specified things for which the search is made. He may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion of the commission of any offence. Now, process to compel production of things is the summons vehicle. The process to compel production of things in court by issuing summons under 91 to 92, by issuing search warrant under 93 to 96, issue of process to compel, then search of a person wrongfully confined is section 97, restoration of abducted female is section 98. Now, security for keeping peace, maintenance of public tranquility and preventive action. Sometimes we get an order from the police to come and present before yourself before them. First, and a complaint that is made by somebody else for you have done something. Same thing happened with the magistrate also. In all such cases, these provisions are retracted, section 106 to 124, where you will be asked to give a commitment, a bond for keeping peace and maintenance of public tranquility and preventive action. And also you may be asked to provide security that you will follow the particular instruction of the police or the magistrate. So section 106 to 124 provide provisions for taking preventive measures against persons who are a danger to the public by reason of commission of some offences. Executive magistrate has a jurisdiction to deal with habitual offenders and take security measures for their good behaviour. Habitual offender means a person who is by habit a robber, housebreaker, a thief or a forger, or a habitual receiver of stolen property, habitually protects and harbours thieves or aids in concealment or disposal of stolen property, or habitually commits or abets the commission of extortion, cheating, kidnapping, abduction, and habitually commits or attempts to commit or abets offence under any of the laws for time being in force. Section 129 to 148 deal with maintenance of public order and tranquility. A number of powers are given to executive magistrate and police officers to maintain peace and tranquility by preventive action in case of unlawful assembly, public nuisance, apprehension of danger, and dispute in respect of property and stolen property. Sections 149 to 153 empower a police officer to take necessary steps to prevent commission of cognizable offence, prevention of injury to public property, and inspection of weights and measures. Now here we have reached a particular stage where police will swing into action. The police action is covered by investigation. After FIR, police action will start, investigation will start. This is covered under sections 154 to 176. Police investigation, police officer, any person authorized by a magistrate, mostly police officer or somebody who is in related departments, has power to investigate and collect evidence under CRPC under following subjects. 1. Proceeding to the place of offence. 2. Ascertainment of facts and circumstances of the case. 3. Discovery of material evidence and arrest of the specified offender. 4. Collection of evidence by examining various persons and search of place and seizure of things. Next, let us see what is FIR. FIR is an important document and evidence in criminal proceedings. Initial investigation procedure is it starts on the basis of an FIR in a court. Legally speaking, information given to a police officer reduced to writing as required under section 154 of CRPC is the first information. FIR legal aspects are: any person can give information of a cognizable offence to the police. Information has to be given to a police officer having jurisdiction. If you don't have a jurisdiction, you can file a zero FIR, which can later on be transferred to the police officer who has jurisdiction. Police officer must reduce such information into writing. Police officer must make signature of the informant. Recorded information must be read over to the person who is informing you. Police officer must make an entry in the general diary about such information. Police officer must keep a copy and give a copy of such information FIR to the informant. Police officer must send the FIR to the magistrate under section 57 of the code. Section 157 of the code, procedure of investigation. If a police officer refuses to record the information, the aggrieved person can send it by post to the superintendent of police, or under section 154 clause 3, or he can file a complaint with the magistrate. Examination of witness by police officer. Police officer may examine the person who is acquainted with the facts of the case at the time of investigation and reduce the statement made by such person into writing. This is known as the statement under section 161 CRPC. Recording of statement of confession. According to 164 CRPC provides provision for recording of confession by a competent magistrate. Remember, a confession given to police officer or confession given to any person in the presence of a police officer, even when the police officer is within the hearing range or a visible range, is null and void. So, to be valid, a confession and an admission has to be done only to a competent magistrate, and even in that, the magistrate has to certify that you are fit enough to give an admission or a confession, and then you should make sure that the police officer is nowhere in the vicinity of either hearing or vision. Section 164 CRPC provides provision for recording confession by a competent magistrate. The rules regarding recording of confession statement are: 1. It must be recorded by a judicial magistrate first class or second class. If an executive magistrate records a statement, it is not useful as an evidence. Only judicial magistrate. It can be recorded in the course of investigation or at any time afterwards, but before commencement of trial. Judicial magistrate must give warning to the accused person. They are called Miranda rights. Okay, before recording of such confessional statement, the warning is: you are not bound to make a statement, and if in spite of my warning you give a statement, then it will be used against you. The object of this warning is to protect the rights of the accused person guaranteed under Article 20 Clause 3. These are called Miranda rights in USA. That's known as Miranda rights, which provide that no person accused of an offence shall be compelled to witness against himself. Magistrate must disclose his identity. If the recording is postponed, he must give fresh warning to the accused person. Magistrate must have reason to believe that the confession is voluntary, and if it is not voluntary, he should not record such a statement. Magistrate must give sufficient time to the accused person to think and answer. If any injuries are found on the accused person, magistrate must inquire about them and give a record of them. If the accused is handcuffed, the magistrate must order for removal of such handcuffs. If the accused refuses to make a confessional statement, he must send him to judicial custody and not to police custody. Magistrate may ask reasons why he wants to make a confessional statement. Magistrate must put questions to the accused person to ascertain his voluntariness and the status of his mind. He must be recorded only when it is made by his own will. Magistrate must see that the mental condition of the accused person can satisfy the voluntariness. If the accused knows to write, magistrate can ask him to write. Magistrate must explain the accused about his right to consult a lawyer as provided under 22 Clause 1 of the Article Constitution of India. No oath is administered at the time of recording such a confessional statement. Magistrate must record such statement in an open court if it is possible. If the case is in a different jurisdiction, he must send a copy of the recorded statement to the magistrate who has trial powers. The magistrate recording the confessional statement is also required to follow the procedure given under CRPC and circulars orders of the High Court. Now, inquest by police. When an officer in charge of a police station receives the information that a person has committed suicide or has been killed by other person or by an animal or by suspicion that some other person has committed an offence, he shall immediately give information to the nearest executive magistrate to empower to hold inquest, shall proceed to the place where the body of such deceased is there. When a person dies in the custody of the police, it is the duty of the executive magistrate, judicial magistrate to conduct an inquest. Okay. Now, initiating and commencement of proceedings, section 190 to 210. So, investigation is over. After completion of the investigation, police will give a final report or a police report to the magistrate. It will be attached with the charge sheet. Okay, then giving list of charges which have been likely to be, the person is likely to be tried under. Actually, the charges are to be next framed by the judicial magistrate. The charge sheet is the letter submitted by the police to the judicial magistrate. Any magistrate of first class or second class may take cognizance of any offence upon receiving complaint or upon a police report and upon his knowledge that offence has been committed. There are three ways you can do it, just magistrate to do it. One, a complaint from any of the public, member of the public. Second, a police report from the police who have investigated the case. And third, when a thing has happened before him and he has personal knowledge about it. And cognizance by magistrate. The term taking cognizance means any judicial action permitted by the court taken with a view to eventual prosecution preliminarily for commencement of inquiry or trial. It does not involve any formal action and indeed action of any kind, but occurs as soon as the magistrate applies his mind to the suspected commission. First class judicial magistrate may take cognizance on the following circumstances. What is this? One, cognizance upon receiving a private complaint. Second, cognizance upon receiving a police report. Third, cognizance upon information from his own sources. Fourth, cognizance upon the information received from other sources. If in the opinion of the magistrate taking cognizance of offence there is sufficient ground for proceeding and the case appears to have a summons case, he shall issue summons for attention of the accused of it is awareness of the case. He may issue warrant if he thinks fit that summons may be issued. If a proceedings is instituted upon a complaint made in writing, every summons or a warrant shall be accompanied by a copy of such complaint. If that case is triable by magistrate, he can proceed. Commitment of a case. In case where it appears that the offence is one triable exclusively the court of session, that is about 2 years, then the magistrate need not, before committing the accused, make any elaborate preliminary inquiry except in case of a private complaint. But he shall commit the case accused to the sessions court and send the records of the case along with documents and articles to be produced in evidence. He may grant bail or remand to custody as is prescribed under CRPC. Next, the step after this is FIR is over, investigation is over, the police report is over, magistrate has already taken a cognizance of the crime. Then next stage is charges. Charge sheet is given by the police. Remember, there is a difference between the two. Charge sheet is one word, framing of charges is another word. Charge sheet is submitted by the police as a part of their final report, whereas framing of charges is done by the magistrate. The charges serve the purpose of notice or intimation to the accused person. It draws up according to specific language of law, giving clear and unambiguous or precise notice of the nature of accusation. The accused is called upon to meet in case of a trial. In a criminal trial, the charge is the foundation of the accusation and every care needed to frame it properly. Section 211 to 224 of the Code and Chapter 17 deal with the form of charges and joinder of charges. Every charge shall state the offence as per IPC or other similar law with which the accused is charged by referring specific name of the offence, contents which constitute an offence, elements of the offence should be mentioned, section of law and shall be written in language of the court. If the accused has been previously convicted, details of such conviction must be mentioned in the charge. Essential features of the charge can be understood like 1. Head of the charge. 2nd. Charge is framed by courts only in warrant cases and not in summons cases. 3rd. Charge should be certain and specific. 4th. Court has the power to alter the charge. Basic rule laid down is for every distinct offence there shall be separate charge and every charge shall be tried separately. Form of charge. Charge must include the below information. Charge must state the offence, name of the offence committed in Indian Penal Code or any another act, name of the offence or a definition of the offence in case of no name is there, then section of law he is charged with, then it must be in writing, details of previous convictions if any, section of law is charged, it must be in writing, details of previous conviction, time and place of alleged offence. In a criminal breach of trust case, dishonest misappropriation, details of the gross sum amount is to be given. Breach of trust can be tried at one trial, whereas such offences are committed in the space of 12 months. Relaxation available only to criminal breach of trust or dishonest misappropriation. In case of alteration of charges, procedure to be followed is as per code. Alteration can be done at any time, but before the judgment is pronounced. Court may frame charges in summons cases. After alteration of charges, court explains about it to the accused, and he can also direct for new trial, or he can proceed. Whenever a charge is altered, allow the prosecutor or the accused to re-examine and re-summon the witnesses. Next stage is trial and judgment. So, the CRPC has adopted 4 modes of trial. So, this will start in the next class because it needs a bit more of discussion. So, if you have any doubts up to this, you can ask. Poonam.
No, sir, I'm okay.
Yeah, you can also download this. I am putting it in the Telegram channel and
Okay.
in WhatsApp also. This particular material, written material, you can download it and read it and come for the next class tomorrow again at 6 p.m. Now you can leave the class.
Thank you, sir.